Hi everyone, I'm Monique with MSCI. Thank you for joining us. We're presenting contract basics today. I sent an article to you about a half an hour ago called Decoding Legal Mumbo Jumbo. If you did not receive it, please let me know and I'll resend it. If you have questions during the presentation, you can type them to in the question box to the right of your screen, and we'll get them as you send them in, so please feel free to do that. And now I'll hand it over to Mark McCareins, General Counsel to MSCI.
Thank you, Monique, and thank you for the opportunity to chat with everybody today on what I believe to be a very important topic, and that is commercial contracts. Let me say at the outset a bit of a disclaimer that I am not in any way, shape, or form providing legal advice to you or your companies today. And in addition, I'm not trying to replace your own lawyers or advice they may have given on these topics. What I am trying to do is to provide business people like yourself with some contract basics so that as you do your respective jobs, you have some background and context as to how the law treats contracts and determines how they will be enforceable. Let me say at the outset as well that we're talking today about commercial contracts. There's a whole other world of consumer contracts, and we collectively as consumers sometimes do dumb things like we buy cars that don't fit in our garages, and we buy refrigerators that don't fit in our kitchens, and we are allowed under certain circumstances to return those items because in essence we're foolhardy consumers. Those types of relaxed contract standards that apply to consumers do not, I repeat, do not apply to commercial business transactions. And that's a point of emphasis today for our ongoing discussion. A little bit of my background and how I come at this topic. I come at it with really three different lenses. For over 30 years, I practiced commercial litigation with a large global law firm in which I was hired and retained by companies like yourselves to defend and litigate contract disputes. So I have worked with executives and business people for many years in enforcing contracts. In addition, I have a faculty appointment at Northwestern's Kellogg Graduate School of Management, where I teach, among other things, contracts and business law to MBA students. And lastly, and as importantly, I am the general counsel of MSCI, where as a routine matter, I'm reviewing contracts for MSCI on a daily basis. So it's those three perspectives that I bring to this topic. With respect to Monique's observation about questions, feel free to ask them, and there's a little question box here that they should appear in. If your questions relate to a topic that we're talking about at that moment, I will try to break in and answer your question. On the other hand, if it's something that is a little outside the scope or should be dealt with at the end in our question and answer period, we'll do that. But feel free to keep the questions coming. So without further ado, let's jump into the contract discussion, which starts with the basics of what is a legally enforceable contract and why do we have contracts. The purpose of contracts is to memorialize business agreements and preserve the parties' expectations, but more importantly, to provide a legal mechanism in case there is a dispute about either the terms of the contract or the performance of the contract, which we would call a breach situation. So in order to create a legally enforceable contract, one that would be enforced by the courts, there are four requirements. They're outlined on the screen: mutual assent, consideration, capacity, and lawful purpose. And let me talk about each one of those in a little bit of a detail. First, mutual assent. That is really the hallmark of any consensual contract, and that means that there has been a valid offer that has been communicated by one party to the contract, an offer that has been accepted. And we call that moment of acceptance the magic moment or the meeting of the minds, and that really creates mutual assent. Without mutual assent, we don't have a contract. So an example might be if one party offers a set of terms to another party and the receiving party, who's called the offeree, does not accept all the terms, but simply accepts some and then counter offers on the others, we don't have mutual assent. We don't have mutual assent until the party receiving the counter offer has agreed to all those terms. And as you probably know from your experience in business, many times that process of back and forth may go on for days, weeks, and or months. But at some point in time, at the conclusion of that process, there must be mutual assent. And that is memorialized by a final offer being accepted unequivocally by the receiving party. One other note about mutual assent and offers. This is very important from your standpoint in determining what are going to be the parameters of the arrangement. A valid offer must contain the important stuff or material terms that are to be a part of the deal. Price, quality, time of delivery, place of performance, etc. If the offer does not contain the material terms, even if there's acceptance, there cannot be mutual assent. So, if the offer is like Swiss cheese with lots of holes, even though somebody takes a bite of the Swiss cheese, that's not acceptance. We have to have a complete piece of cheese without any holes to have acceptance. That's important from another aspect, because you as contracting parties, one of the primary reasons why you want to enter into a legally enforceable contract is to make sure of what? That there's no uncertainty, there's no ambiguity, and there's clarity and certainty of the terms. Because at the end of the day, if you have mutual assent in a legally enforceable contract, you want to be in a position to say to yourself, I've done it, we've set out all the material terms, we've had agreement on it, and now we can go forward. So the first component to a legally enforceable contract is mutual assent. Excuse me. The second is consideration. And in law school, we might spend months on this topic. Here, we'll spend about 90 seconds. Consideration is a legal requirement to an enforceable contract, and it requires each party to the contract to give up something to get something in return. Typically, it's money. So if ABC Widget is selling widgets to another party for $1 a widget, ABC Widget is giving up control of the widgets in order to get the $1 per widget. And typically, that's how consideration works. It can be a lot vaguer than that, but at the end of the day, it's a promise. It's a promise to do something, and the other side is promising to do something in return, usually make payment. That's consideration. If, on the other hand, the transaction is one-sided, so that there's only one side making a promise, and the other side is not making a promise in return, in that case, we don't have consideration, and then we don't have a legally enforceable contract. The third requirement, capacity, is pretty self-explanatory. We must have parties of a certain age and a mental state in order to engage in this voluntary consensual process. My 16-year-old son would be incapable of entering into a legally enforceable contract because he is not of capacity. Lawful purpose, this gets a little tricky. We can do anything we want in a contract as long as it's not illegal. So if I had a contract with someone to do harm to Monique, who's sitting next to me, and we had mutual assent and consideration and we had capacity, that contract would not be legally enforceable because the purpose of doing harm to a third party is not a lawful purpose. That begs the question, though, in the business context, what is lawful and what is not? And that certainly is a question for your individual lawyer at times, because these contract questions are driven by state law. Since we have 50 states and since we have a wide variety of views on that subject, what may be legal in one state may not be legal in another. And again, I'm not giving legal advice, but for an example, the state of California takes a very dim view on non-competes. So if there's an employee restriction embedded in an agreement which prohibits a company from an employee from competing with that employer for some period of time after termination, that may be illegal as a matter of California law. That same provision might be legal in Illinois. So again, generally, we must have lawful purposes, and if the object or purpose of the agreement is not lawful, it will not be legally enforceable. What then if one of these or more of these requirements that are on the screen are not met? There is an alternative approach for a contracting party, and that is to sue in equity to seek an equitable result from a court and say, I didn't have a legally enforceable contract, but I conveyed value to another party, and I would like the equity judge to make some sort of award in terms of compensation for my efforts. That whole subject of equitable contracts is a little outside the scope of this presentation, but I wanted to plant the seed in your minds that that is an outcome if one or more of these basic elements are not met. A question that comes up in connection with these requirements quite often is, do my contracts need to be in writing to be enforceable? Generally not. There is a rule called the statute of frauds, which does require that certain types of contracts must be in writing to be enforceable. Those limitations include sales or transfers of real property or real estate, or sales of goods in excess of a certain amount, let's say $500. So in order to be a legally enforceable contract, those types of agreements have to be in writing. Generally, though, many agreements do not have to be in writing to be enforceable. The key here, though, before we proceed with the next slide, is to ask you folks as potential contracting parties to make sure as you're going through the contracting process that you have mutual assent, that your offer is embedded with all the material terms. And in fact, if there are ambiguities, if there are uncertainties, if there are points of the deal that are not expressed, that opens up a Pandora's box of dispute later on, either in the form of a party saying we don't have a contract because we don't have mutual assent because the offer was like Swiss cheese, or the party saying we do have a legally enforceable contract, but we're at odds or we're disputing each other's interpretation of the terms. That, from my vantage point as a trial lawyer being retained by companies to debate these contracts, is a worst case scenario for business people. Litigation over contract terms is a losing proposition for everyone, with the exception of the attorneys who are paid to defend or prosecute the claims, because under our American rules, the loser does not pay the other side's legal fees. Those contract cases can bleed on for years. The expenses with that are substantial, and at the end of the day, you are asking a judge, albeit a lawyer, to interpret or reinterpret what the party's intent was at the time of contract, and that is a very dicey, risky thing. If you're a fan of going to Las Vegas and playing gambling games, I would heartily encourage you to engage in contract litigation warfare. If not, if you're a little more conservative, kick the tires of the offer prior to mutual assent. Kick the tires to make sure that all potential contingencies in the proposed transaction have been discussed by the parties. Lastly, and I know I just said lastly, one more lastly before we get to the next slide. In terms of the mutual assent, excuse me, I think it's good guidance going forward that as you're trying to determine what your terms are and what your offer looks like before there's acceptance, have you done the best job possible to quantify or provide metrics of performance of what you expect the other party to do? Because the softer those expectations are, the more qualitative those expectations are on the contract, the greater the chance that there are disputes later on about performance. So, for example, we may have heard of a clause called a best efforts clause. I contract with Monique to perform a service and that she is obligating herself to engage in best efforts. That is legally enforceable. That is sufficient consideration that she's going to give her best efforts. But at the end of the day, and Monique finishes her performance, and I say, wow, Monique, that's not what I expected. And Monique says, I don't know what you expected, but I used my best efforts. Now we're at loggerheads over whether she used her best efforts or not. She's saying she did. I'm saying she didn't. How do we determine whether she did? So even though the clause itself or the term or condition might be enforceable on its face, does that really do an adequate job of measuring expectations before the contracting relationship starts? Instead of best efforts, I would say, is there a way to provide some metrics of performance? Timing, quality standards, specifications, scope of work, to really quantify best efforts. And I would encourage you going forward to do as much of that as you possibly can. That really will help you in the long run in terms of contract enforceability. My next slide is sort of a copyrighted phrase of mine, although there's no copyright designation. And it's meant to provide you with the insight that contracting itself under U.S. law is a very, very powerful tool. It is a very creative tool, but it is a private consensual agreement between two contracting parties with capacity. If for some reason you find it appropriate to call a cat a dog in your contract, and that's not illegal to do, and I think in all 50 states it would be legal to call a cat a dog if you wanted to do that, the law will enforce that agreement. Now, it sounds silly, but take this into the practical world. If for some reason you are uncomfortable committing to a time period in which a month is defined as 30 days, or as a month 28 days, or 31 days, or what about leap year? If you want to define a month as 24 hours in a contract, and both parties want to abide by that definition, then it's enforceable. And that gives you a great deal of flexibility and creativity to define your own relationship going forward, and the law will enforce that. In addition, I think it's very important for you to view contracts not only offensively, but defensively. Offensively in the sense of, how can I use contracts to better protect and promote my business? Defensively, when a standardized pre-printed contract is presented to me, how should I respond to that? And we'll get into that in greater detail later. We don't go into in this webinar a lot of discussion about rules of contract discussion, but I thought it was important at this point in time to talk about one, and that is what's called the parole evidence rule. So if you're on Jeopardy and the topic is contracts, this would probably be a $500 question. Alex Trebek or whomever would say, what is the parole evidence rule? Or I guess that would be your answer. But the parole evidence rule means that if you have an expressed written agreement at the culmination of your contracting process, which I heartily recommend, the express written agreement is the best way to go, whether it's required or not. All the stuff, if you will, all the negotiations, the drafts, the term sheets, the representations leading up to that final express agreement are ignored. So in the business world, it is certainly not uncommon, as you're beginning the contracting dance, for people to say things that they either A, can't fulfill, or B, don't have authority to do. Now, when the final express written contract is presented for your signature, if those things are not included in the final express written contract, they are not part of your deal. So your opportunity to go back after the fact and say, hey, you told me that delivery would be made on a certain time, and it hasn't been. The contracting party who has some level of legal sophistication will say, au contraire, the parole evidence rule suggests that whatever I said to you leading up to the final express written agreement is going to be ignored. So what does that tell us as business people who are starting the contracting party? First, do not trust anything that anybody is telling you about what they're going to perform or when until it's in the final express written agreement. And when it comes down time to sign the final express written agreement, that is your best and potentially last opportunity to go through that agreement with a fine-tooth comb and pick out those things that are not included. So if the time of delivery or performance was not included, before you manifest your intent to the agreement and sign it, you say to the other party, hey, we talked about time of delivery. It's not included in the contract. What's up? Why isn't it in there? And if the other party says, or words to this effect, don't you trust me? I would respectfully suggest to say, not really, but I would really trust you if it was in the written agreement, because that's what's going to control our relationship going forward. If they say, for example, well, that's okay, we'll get to that later, just sign the contract, that is your red flag and your last opportunity to say, do I really want to sign this contract without that commitment, or is it something I can live with? Because once you sign that contract and manifest your intent to the agreement, and all four legal buttons have been pushed, consideration, capacity, lawful purpose, and mutual assent, then the time for undoing or reworking a contract is pretty much over. Even calling a lawyer who specializes in contract litigation after the fact, as we will soon see, is not a healthy exercise for business people, because the opportunities to undo or rework that contract are very few and far between. Again, in the consumer setting, no problem, virtually no problem, you can undo things. In the business setting, not so clear. So prior to you signing that agreement, that is your opportunity to go through it and make sure that every material term that you discussed is in there. And if the other side of the party to the contract says, no, I won't include it, you have to ask yourself, why not? Why are they saying that? Because they're not going to perform that, probably. And probably because they have enough knowledge of contracts to know that if it's not in the final express written agreement, they're not going to have to perform it. A way to memorialize that parole evidence rule, and we'll get to some standardized terms a little bit later, is what's called an integration clause. So if you've seen that integration clause in standard pre-printed contracts, that is simply a memorialization of the parole evidence rule. The integration clause will say, or something like this, everything that was done between the parties leading up to the time of the written contract is meaningless. Everything is integrated into the final express contract. And if it's not plainly on the face of the final express contract, it's not any party's obligations. So as you read or look at contracts going forward and you see an integration clause, that's why it's there. In addition to these contract basics, there's also something I might mention, although we don't have a slide on it. Many of you are in the metals business, obviously, and you're selling product, hard, tangible goods. There's another body of contract law called the Uniform Commercial Code, or UCC. And the UCC is a codification of these general contract laws and has been adopted by most states where there's a sale of goods. And again, the UCC has some relaxed standards which are a little bit outside the scope of our presentation today, but again, it only applies to the sale of goods. So if you are renting or leasing products, the UCC does not apply. If you're selling services or mixed services and goods, the UCC may not apply, and these traditional kind of hardline contract rules are going to rule the day. So I alluded earlier to the lack or paucity of defenses for commercial contracts, and they are laid out on this screen. And I can't underestimate to you today the value of recognizing up front that once the four contract basics are met and there's mutual assent, consideration, capacity, lawful purpose, and the contract's been executed, you are pretty much stuck. So it becomes incumbent on you and your obligation in your business world not only to make sure that all the material terms are there, but that you understand them and appreciate them and understand the significance. Because the opportunity to say after the fact, oh, I didn't know what that meant, or oh, I didn't really understand that term, or oh, if we really interpret that term the way it says, my business will be ruined. Judge, please let me out of the contract. In a commercial business contract world, those are not defenses. Those defenses relating to fairness, the word unconscionability, or even unequal bargaining power or economic duress in the formation of the contract. You may have heard that phrase before, economic duress. Let's say I'm a widget manufacturer. There's a shortage of gadgets that I need to make my widgets. And I go to Monique, who's the CEO of ABC Gadget, and I say, Monique, I need some gadgets. And Monique says, well, I would have sold them to you for $1 a gadget a couple months ago. The market price is $2 a gadget, but today I'm selling them for $5 a gadget. Take it or leave it. And I say, Monique, you're driving a very hard bargain. You're really taking advantage of me. You're being very unfair. You're being unconscionable. You're giving me a take it or leave it proposition. But unfortunately, I can't leave it. I have to take it. So I signed the contract with Monique at $5 a gadget, and after a couple of months of paying her this exorbitant above market price, I turn to Monique and I say, I can't keep paying the $5. I know we have a 2-year agreement, but I got to get out. This $5 a gadget is killing me. And Monique, who has been very diligent about paying attention to these contract basics, says, unfortunately, you weren't paying attention when Mr. McCareins was going through that slide, because we have a legally enforceable contract, and the fact that it's unfair to you, or it's turned out to be a bad deal, or that you have suffered some economic duress as a result of entering into the contract, is not a defense. Your lack of appreciation, full appreciation, understanding of a term, not a defense. Fairness, unconscionability, lack of even bargaining power, not a defense. The only defenses that are available relate to fraud and mutual mistake, and those are very limited and very hard to establish. Fraud is that you, as the party who's trying to get out of the contract, has to prove that the other party to the contract, in this case Monique, had an intentional mindset. So I have to prove intent. That's very hard. Unless she's going to admit that, that's very hard. She's probably not going to admit it after she's talked to a lawyer. Intentional misrepresentation, not concealment generally, not silence, but an active misrepresentation, to me, of a material, meaning important, fact. So in my contract negotiations with Monique, and we're talking about these $5 gadgets, I say to Monique, Monique, do you think these gadgets might work in my widget? And she says, sure, I think they'll work fine. Turns out I buy the gadgets, I put them in the widgets, and they don't work. There's nothing in the contract about performance standards or specificity, so I failed that test. Now I call a lawyer and I say, Monique defrauded me. I want out of the contract. And after the lawyer sends you a bill for several $1,000s, the lawyer concludes, no, there's no fraud. Because even if we could prove intent, Monique misrepresented maybe something, but it wasn't a fact. It was a qualitative, subjective opinion about whether it would work. And I'm sure she would say, if sued, I did think it would work, and I can prove that. So again, you hear fraud mentioned all over the place in the papers, in Wall Street Journal, almost on a daily basis, but it's very hard to prove, especially in a contract case. The second, mutual mistake. If both parties are mistaken about something important, we can undo the contract. But again, that requires both parties to be mistaken about something. Unilateral mistake or one-sided mistake in the contract is not a defense. So if I go into this same situation and I say, Monique, we need to undo the contract because I thought I needed your gadgets, but I was mistaken. I really don't need the gadgets to make the widgets. And Monique, again, after paying attention in this webinar, taking good notes, says, I'm going to hold you to that contract because your unilateral mistake is not grounds to get out. If we were both mistaken, or if I want to be a nice person and undo the contract, we can always, in a voluntary, consensual way, terminate a contract, but I'm assuming a worst case scenario in which people in the business world may not be so nice. Monique may be saying, wow, I'm getting $3 a widget above market for the next 2 years or gadgets. I think I'm going to keep this going. Otherwise, I'm going to undo the contract and lose all that money. So the idea, again, in the commercial business context, that there are defenses post-contract that even with a good lawyer you can get out, I am here to tell you that you should not rely on that. Again, pointing to what? Pointing to the magic moment prior to contract, prior to when there's mutual assent, is the time at which you need to do your homework. Do I understand my obligations? Do I appreciate the implications and seriousness of those obligations? Are all the obligations spelled out with clarity? Are the what ifs? What if this happens? How are we going to address it? That's a very good exercise, a due diligence to do pre-contract. Not a good exercise to do post-contract. With respect to standardized or pre-printed contracts, which many of you have probably both used offensively and defensively, and this observation probably won't be a surprise to you, is that a lawyer has drafted up those contracts or documents for a fee. And the client who has engaged the lawyer to draft the standardized or pre-printed contract for a fee probably rarely says to the lawyer, please draft up a nice, fair, even-handed contract. It is usually, or words to this effect, for the exorbitant fee you're charging me, I want you to draft the most aggressive, one-sided contract that you possibly can, as long as it's not illegal. And you get this standardized pre-printed contract with 42 different conditions, and you print it up and you start using it in your business. And that's this phrase, legal mumbo jumbo, which Monique sent around the article before. When you receive these standardized pre-printed contracts in business, and you don't have one, you should assume that every clause in that contract has meaning, and every one of those clauses is probably enforceable and should be questioned as to why it's in there, what its purpose is, and whether it's really necessary. The person who presents you with the standardized pre-printed contract and says, oh, with respect to clause 43, that's just legal mumbo jumbo. The lawyers put it in there. I don't really know what it means, but we need to have it in there. And you're supposed to be satisfied with that response? No, do not be. Understand what it is. And again, we're going to go to the back page here shortly, but if it means consulting with a business attorney, a contract attorney before you manifest your intent to fully understand what all these terms mean, you should definitely spend the money then, because spending the money after the fact is probably not a good investment. In addition, by going through those pre-printed terms, you may come across some terms as you then understand them that you simply won't agree to. And then your power and art of negotiation kicks in. You go back to the other party and say, I have reviewed the contract, and the following 3 provisions, paragraphs 3, 17, and 31, I'm just not going to agree to. So now it's take it or leave it. I'm just not going to obligate myself and my company to those terms. And surprise, surprise, there may be the majority of contracting parties who say, okay, I want to do the deal. Let's take them out. You've done your job. That's the time to do your job, to look at that contract and go through those terms before you manifest your intent to it by signing it. The idea, too, that with these standardized or pre-printed terms, that they are being proffered or offered by big, large companies to take advantage of small companies, and therefore, if the small company signs the contract, that ultimately there should be some defense to allow you to get out of the contract. As we talked about before, no, there's no big versus small defense in commercial contracts. Side note, in the consumer world, you might have a leg to stand on. But whether you're a small business or a big business, you're still a business. And the contract laws presume that you have these basics and have a good understanding of them, meaning that you understood the terms before you agreed to them. And if you didn't understand them, shame on you. And you should suffer the consequences unless you can prove fraud or mutual mistake. Now, let's get into some of the basics, and I've got some others that I can talk about beyond these that are usually in standardized pre-printed contracts. And I just wanted to walk you through in the time that we have remaining about what these terms mean and the significance of them. The first, the waiver of a right to a jury trial through an arbitration clause. A couple of different points there. It's interesting, let alone a little ironic, that at the time of contract, people are already thinking about what happens if there's a breach and how will a lawsuit look. But again, that's the point of a contract, to anticipate future events, so that if there is a breach or a broken promise, how will we remedy that? How will we adjudicate that? Many companies may say, well, I'm a big company and I'm entering into a contract with a small company, and juries in particular may not like big companies. So in my contract, I want to make sure that if there's a dispute, the matter is not heard by a jury. And there's clauses that say waiver of right to jury trials. I would respectfully suggest that the reason that's in a pre-printed contract is because the party that you're contracting with does not want to have a case in front of a jury. So it's to their advantage to get you to agree with that. Now, is that and all these other clauses legal? Are they enforceable? You can call a cat a dog. You have a right to a jury trial, but if you want to give it away, you can in a contract. Another fairly common clause is the arbitration clause, and some of you may be very familiar with that. I have had clients over the years that love arbitration. I have had clients that do not like arbitration. But in any event, if you are agreeing to an arbitration clause, you are saying in the event of a breach, there will be no court action. There will be a private arbitration. And then it becomes incumbent on the parties to spell out the rules of engagement for the arbitration. For example, how many arbitrators will we have? Should we have 5 or 3 or just 1? Because that might be cheaper. I was involved in one litigation where the parties, which I did not consult on before they signed the contract, chose arbitration. That's fine. But they said that there would be 2 arbitrators. And how would the arbitrators would be chosen? Each party would choose an arbitrator. So one side picked their brother-in-law, and the other side picked their brother-in-law, and then we had 2 brother-in-laws who were the arbitrators. Now, how are you going to break that logjam? Very hard to do. So you want to go the arbitration route, that's fine, but spend a little time with your counsel thinking about what's the best way to position them. Again, arbitration has its pluses and minuses. There's generally very little opportunity to appeal. The rules of evidence are relaxed. There may be a tendency by the arbitrators to kind of split the baby. If you have a super strong case, maybe the other side gets something just to get something. Those are all things probably, again, outside the scope of this webinar. But that's the point of the arbitration clause. Connected to the arbitration and the waiver of right to jury trial, something I did not put on the slide would be either choice of law or choice of forum clauses. So choice of law. Although MSCI is a New York nonprofit corporation, our principal place of business here is in beautiful, rainy Rolling Meadows, Illinois. And we insist as kind of an MSCI policy that when we enter into a contract, which we do, that the law governing any disputes would be Illinois. Why? Because Illinois has great laws? Not necessarily, but we understand and appreciate the nuances of Illinois law. If a party came to us, and they have, and said, let's make Wyoming law control if there's a dispute, I'm not an expert on Wyoming law, and I would have to hire somebody to become an expert on Wyoming law before I figured out if there were some nuances of Wyoming law that I didn't want. So as a corporate matter here, we try as best we can to have Illinois law. The choice of forum, in the event that there's a dispute and you don't have arbitration, or even if you do, where will the proceeding take place? If I'm entering into a contract on behalf of MSCI, I would prefer that that action occur in Cook County, Illinois, because if it's we're dealing with a contracting party in Mobile, Alabama, I'm not too excited about going to Mobile to litigate a case on behalf of MSCI because of the additional expense and having to hire maybe unfamiliar counsel. But all those terms are in there. Choice of law, choice of forum, arbitration, waiver of jury trial right, not just for fun, but they are calculated, and they are calculated to be enforceable, and they are believed by the person preparing the pre-printed or standardized contract that those terms will favor them. So if you're on the defensive mode and you get one of these contracts with one of these choice of law or choice of forum, that's the time to say, okay, if there's a dispute, is that going to be okay that I'm going to litigate this dispute in some other part of the country? The next one, liquidated damages, is one that we could spend quite a bit of time on, which we don't have today, but it is a very, very powerful contract clause and fairly standard. And it's an attempt by the contracting parties to estimate in advance, if there's a breach or non-performance, what the damages would be. So going back to my example with Monique, and I think she wondered today why I wanted her to sit with me during the webinar. Now she's knowing she's my foil. So back to our contract in which I'm purchasing gadgets from her for $5. I might include a clause, or she might include a clause in that contract that says, if there's a breach, the breaching party agrees to pay $50,000 in damages. That's a liquidated damages clause. So then, if there's a breach, we don't have to go to the time and trouble of estimating damages. And those clauses will be enforceable unless certain conditions are met. So here's the irony of that. Let's say my contract with Monique was worth $5,000 a year. I was buying 1,000 gadgets at $5 a contract, $5 a gadget. And mid-year, I just pulled a plug and I said, Monique, we're done. I can't do it anymore. And Monique had this little smile on her face. It might even be considered a smirk to say, okay, if you want to breach, go ahead, but remember paragraph 24 of our contract, liquidated damages. If you breach, you're going to pay me $50,000. And I say, oops, I didn't read that, or I didn't understand that, or I didn't appreciate the significance of that, or I had forgotten about that. That's a bad oops, because that clause of $50,000 in that particular fact pattern is probably going to be enforceable. Again, not giving legal advice, but probably enforceable. And that's a penalty or near penalty that a party may stick in a contract, and it may help them exaggerate damages, or it may minimize damages. I mean, we have cases where a service provider would say, I'm going to provide security services to your building, and you're going to pay me $1,000 a month for a year. And but if there's a breach or if there's negligence on my part and I don't respond to an early warning of a break-in, the liquidated damages is going to be $5,000. So I'm paying $1,000 a month to some security firm. 6 months into it, there's a break-in, there's a breach. I lose $5 million worth of inventory, and I call up the security company and I say, how did you let that happen? They said, well, things happen, and we covered that in the contract. And I say, how did you cover that in the contract? Well, that was paragraph 17, liquidated damages. If there's a breach, we are estimating damages at whatever the figure was, let's say $25,000. And I say, but I just lost $5 million worth of uninsured inventory. And the other party will say, tough luck. Here's your check for $25,000. You're out the balance. That can be a very draconian clause, that being liquidated damages. But again, you can use that offensively or defensively. Indemnity or warranty provisions, very common in standardized pre-printed contracts, very common in the sense that it's one-sided. So it's not unusual for MSCI to enter into contracts with service providers, vendors, hotels. There's an indemnity provision that usually says if something bad happens, we're not responsible, you are. Then I would say, well, that's a one-way street. We're not going to do that. It's either going to be two-way, it's going to be mutual. You accept responsibility for stuff you should accept, and we'll accept responsibility for stuff that we can control, or we're not going to have an indemnity provision. But what we're not going to have is a one-way indemnity provision where the only one who gets benefit from it is the other party of the contract. Losing party to pay the attorney's fees, the prevailing party, as we talked about before, under our U.S. system. If I file a lawsuit against Monique for $5 million and I win, but I've incurred $2.5 million in legal fees, my net take from that action is $2.5 million. She is the losing party, generally does not pay my attorney's fees. In contract, can you change that rule? Yes. Why? Because you can call a cat a dog. So if I want to put it into the contract, Monique, if I have to sue you and I win, I get my legal fees, reasonable attorney's fees, is what it's called, and she doesn't pay attention to it, and I have to sue her, and she's thinking, well, there's this normal rule, I don't have to pay, I'm the loser. If the contract says she's got to pay as the losing party, then that governs. Consequential damages. First, what are consequential damages? They are damages that are reasonably foreseeable at the time of contract as a result of the breach. So going back to my gadget example with Monique, if she was supplying me with gadgets to make widgets and she breaches, she doesn't provide me with the gadgets, I not only have the loss of the contract price on the gadgets, I don't have to pay her obviously the $5 a gadget, but my net profits on my widget sales are recoverable from her as the breaching party, because those are damages that are reasonably foreseeable at the time of contract. So why this is coming up in contract basics is it is not unusual for a party who may be a perpetual breacher to put in a provision like there will be no consequential damages. So if I breach and I'm the breaching party, I'm not going to pay you consequential damages. I may pay you expenses and costs that you may have lost, but I'm not going to pay consequential damages. Is that enforceable? Sure. You can call a cat a dog. Could that be a potentially very powerful one-sided provision? You bet, especially if you're not the breaching party. You decide to sue and your lawyer says, oops, there's a no consequential damages provision. Again, that is the type of legal mumbo-jumbo boilerplate that you might gloss over, and then hopefully as a result of this quick webinar, you start thinking about a little bit more going forward. We've talked about the integration clause. Two other clauses I want to talk about on contract basics quickly. The first clause that I look at in any contract is the termination clause. Under what circumstances can we get out? I'm assuming a relationship will sour for some reason. That's just my outlook on life. I'm very cynical. So I'm thinking at the time of contract, everything seems rosy, but what happens if it turns sour? How do we get out? Are we stuck for a period of time? Do we have to give notice? Do we have to have cause? Is this agreement automatically renewable? Is there an out? So I would suggest if there's one area of introspection that's worthwhile at the time of contract, it's termination. How can we get out? What do we have to do if we're gonna need to get out? Another clause that's fairly common is the parties consenting to what's called irreparable harm. And that means that, back to my contract situation with Monique, if she's agreed that if she breaches, there will be irreparable harm, that means I can go get an injunction. Not that I'm seeking money damages, but that I have an automatic right to an injunction. Again, that's a legal mumbo jumbo maybe, but I don't know if I want to consent to that. Why would I consent to that? Lastly, something called a no waiver clause. A no waiver clause can mean that if there are breaches during the course of the contract, maybe Monique doesn't meet her production goals, the fact that she breaches 1 month doesn't mean that I have to call the contract into play. I can let her proceed for other months, and I don't waive my cause of action. No waiver clause. Again, a very under the radar contract clause that may, in your particular situation, have great meaning. This is kind of a summary of what we've been talking about. Whether it's legalese or legal mumbo jumbo or the lawyers want this, you should assume that all these terms, some of which we've talked about, have meaning, and that the meaning is one that's probably not a positive one for you, especially if you have not drafted the contract. Recommendations going forward, especially with smaller companies that have not a great deal of economic leverage. As I indicated before, I'm not advocating spending lots of money on lawyers for the sake of signing lawyers, but if you're signing a contract that has a potential material impact or effect on your business, the idea that you should just sign it without fully understanding your risks, I think, is misplaced. And the idea that you can, well, if there's a trouble, I can always go to the lawyer. I hope one of the takeaways of today was in a business-to-business contract, there are very little outs after the fact. So I think it is much better, my recommendation, to spend some resources up front to fully understand and appreciate your risks and obligations before the contract is signed. Because once it's signed, the horse is out of the barn and there's very little you can do. Again, as referenced before, it might be after you understand and appreciate some of these clauses better, there is an opportunity to negotiate some. And you know in your own respective businesses, if you're using pre-printed or standardized contracts, not unusual for some of your lower level agents to have some authority or leeway or flexibility to remove some of those clauses. But it's certainly worth the ask once you understand what some of these clauses mean to say, hey, I'm uncomfortable, I don't want it in there, and see what the other party is going to do. Insurance is a kind of an undervalued issue here, and again, we have other webinars from our affiliate members on insurance. If it's a contract risk that you're inheriting as a result of purchasing a business or ordinary course business, and the risk itself embedded in the contract, could be material if there's a breach or you have expenses, that again may be insurable. So it's not been unusual in my situation where there's a contract case and somebody calls me up and says, hey, I'd like you to represent us. And I say, well, do you have business insurance? Well, why would you ask? Well, there may be coverage for that. So do you have coverage? Talk to your risk manager people. Or in the event you don't have coverage for those types of things, that's an insurable risk. On the same point, we talk about, we can negotiate out. Maybe there's some people out there who provide similar goods or services who do not have these types of contract restrictions. So you say to the party who's presented you with this pre-printed contract, I would like the following three terms excised from the contract. And they say, no, we have no flexibility. Well, if they're gadget suppliers, and then I go to Monique, and she's a gadget supplier, and I say, hey, do you have a contract? We do, but we're flexible about it. Boy, that's the time, and that's the time to have that discussion as opposed to after the fact that you have entered into the contract. Lastly, as you can see, I think there's some contract benefits if you don't, in the ordinary course of your business, have standardized pre-printed contracts, to retaining counsel to attempt to capture some of these thoughts in a offensive way. And certainly at the end of the day, I'm a big proponent of express written contracts as opposed to implied or verbal or oral contracts where there can be great confusion as to what's been agreed to. So in any event, it is much better to get it in writing, even though it's not your traditional standardized and pre-printed contract. Monique, do we have any?
We have a question. Is a purchase order a lawful purpose?
If the question is a purchase order a lawful purpose, my short answer to that would be it would be a lawful purpose. The other question that arises from that is a purchase order in and of itself a lawful contract. And it may not be, because there may be language at the bottom of the purchase order that says this is simply a solicitation to offer. It is not an offer of a contract. Again, an example of calling a cat a dog. So whether it's a letter of intent, an NDA, a memorandum of understanding, a purchase order, are any of those contracts? They are, if they meet the four contract basics that we talked about. On the other hand, someone may be fearful of entering into a contract, and they can clearly state in the purchase order or the letter of intent that this is not an offer to contract, it's merely exploratory negotiations. Not seeing any other questions. Certainly appreciate the opportunity to talk to everyone today. And knowing that there may be some Cleveland Indians fans on the phone, I will not say go Cubs, but I will turn it back over to Monique for some final thoughts. Thank you.
Great. Thank you so much, Mark. And thank you all for joining us. If you do have any questions that come up later that you think about, please send them to me. I'll forward them to Mark. And that's it for the day. Thank you so much and have a great afternoon. Bye-bye.